Ja, You may have noticed from your timetable that the replacement class has been fixed for next week, Thursday. That was about the only free day, well, not free day, but the slot we were able to find was between 2 and 4 next week, Thursday. So it's not a great day because that would mean you would have 4 hours of corporate governance in one day. But hopefully we'll try to make it. It's going to be an interesting one because we'll be dealing with risk management. So hopefully the case studies we'll do should make it relatively easier. The relevant room is K. I think K. Well, I shouldn't say it. It's K something. I don't have it off head, but it should be in your timetable. Let me get it here, and I'll send a notice round so that you get it. That's K minus 1.14. K minus 1.14. An email will go round giving you further details. Okay. So our journey so far, just to sort of recollect, is we're looking into the subject of management control. By that I mean, how do we control the management? Remember, management are the full-time people who drive the company. So we need to find ways of controlling them, because if we don't control them, then the theory is that they will incur agency cost, right? They will consume perks and would act in bad faith or would be negligent. And therefore, the theory is that we need to control them, and that is essentially what corporate governance is about. Whilst the law tries to control them through what I call ex post measures, so measures after the event to penalize, not to penalize management, because management are not directors. Management will be penalized under their contracts of employment. Technically, the duty of loyalty of management would be the same, right? But in employment law would refer to it as a duty of fidelity. But the point is that management are controlled through their contracts of employment. So company law, ex post, comes in to penalize those who should monitor management, i.e. directors. So the theory is that if directors do not monitor managers, and managers consume or create agency cost, then technically we would say that the directors are either breaching their duty of loyalty or they are breaching their duty of care. So that's the theory. Corporate governance obviously comes in at an not at an ex post point, but at an ex ante point by trying to give us structures and procedures and processes to ensure that the board is effective. Effective in doing what? Effective in managing or monitoring management. So here I say that if somebody tells me, if somebody is asking about what the board has to do as a matter of corporate governance, I'm going to say to them that they need to know the law. I'm going to Leiden at the end of the month to give a lecture on corporate governance, and I looked at the folks in the university who invited me, and they come from, the usual suspects. They're the usual suspects, the people from sociology, the humanities. And I'm saying to myself, what am I going to talk to these guys about? They don't know the law, but they're authorities on corporate governance. So, remember, that's the point I mentioned earlier at the beginning of this course, which is that corporate governance is a subject which has been appropriated by many groups. But I think this is pretty uncontroversial. If we're going to advise the board, we have to proceed as a minimum that they must be able to comply with the duties imposed upon them in company law. And that's why I start with that point. And we know now that those duties are the duties of loyalty and care. We know that these are the two broad categories, by the way, in virtually every jurisdiction. We refer to them as the duties of loyalty and care. We did say that in jurisdictions like the United States, they tend to mix the two up. But I think we're very clear about this. We know why we don't mix them up, right? Remember I said there's a distinct difference between the fiduciary duty, i.e. the loyalty duty, and the duty of care. And I also gave you examples, at least I gave you one example from a remedial perspective. I don't know if you remember when I talked about limitation. I said if you're going to proceed against directors, if you're talking about the duty of care, then the normal limitation period will apply. But if you say that there has been a breach of trust, then it's a different limitation period, right? Okay. Now, and the other point that I've flagged up and I wish to also talk about as we go along are the constraints to controlling directorial discretion. What are the constraints? So by this I mean, if you say that directors have a duty of, loyalty and care, does it mean that every time things go wrong that the directors should be liable? And the answer is no, because there's a big constraint on the imposition of these duties. And you know what the constraint is, the business judgment rule, right? The business judgment rule. Now, in America, it's a free-blown doctrine. So in American corporate law textbooks, you're always going to get a chapter or a section of a chapter dealing with the business judgment rule. Now, we don't have this, but it's kind of infused into our company law, right? So when you look at case law, going way back, ancient and modern, they always say the same thing. I mean, one of the earliest cases was a company, not even a company law case. This is a case decided in 1812 where Lord Eldon, in a case called Carlin and Drury, said that it is not the function of this court to take the management of every playhouse and brewhouse in the kingdom, right? So the courts were basically saying, we're not going to get involved in the management of, these entities. It's not the role of the court to do this. This is Carlin and Drury, 1812. Remember, the limited liability company as we know it today came in 1844, 1855. 1844 was separate legal personality. 1855, we got limited liability, right? But this principle, this business judgment rule, which is a statement of judicial deference, was always there. The courts were just not going to get involved. And then when we see other cases, and by the way, if I mention a case and it's not there, that's because it's not terribly important for you to have it, right? But obviously, if you want to sort of do the research and I mention a case, then you can, use the audio capture and sort of locate it. But, I only give you cases that are terribly relevant. So the next time we see the business judgment rule being manifested actually is in a slightly different context, right? So Carlin and Drury was before the birth of company law. By the time we get to, say, the 1920s, we see cases like Shuttleworth and Cox, where the courts are basically dealing with the alteration of articles of association, and a shareholder goes to court to say, please do not, please strike down this alteration of articles. Strike down the amendment of the articles of association. And the courts are basically saying, Well, you know, only if you say it's not for the benefit of the company. Then the question is, who decides what is for the benefit of the company? And the court say, well, sorry, we can't. We give that to management, right? So in other words, the courts are basically saying there's a business judgment rule. So even when the shareholders are the ones altering the constitution, notice, not the management now, the shareholders are the ones altering the constitution of the company, the business judgment rule protects that exercise. Now, normally when we talk about a business judgment rule, we apply it to the directors, right? It's a shield protecting the directors so that whenever anything goes bad, the directors can say, you know, we did our best. We're managing a business, right? And it's not for the courts to tell the directors that somehow you got it wrong, right? So it's a shield. It's a statement or presumption of managerial correctness, at least correctness to the extent that the courts are not going to sort of supplant the exercise of their discretion. But the reason I'm mentioning this is to trace the evolution of this doctrine to the board. So notice we started outside company law, Callan and Drury. We got into company law and then began to look at cases like Shuttleworth and Cox dealing with the alteration of the articles. There's another case called Sidebottom and Kershaw dealing with the same point. There's another case called Daffin and Tinplate dealing with the same point. It doesn't really matter. We then, the final stage is when we get to the board. And when we get to the board, lo and behold, you dealt with the case last time, Regent Crest and Cohen. Remember the Regent Crest case where the directors sat on a board and decided to waive clawback claims that the company had, right? They waived those clawback claims on the 5th of September, saying that, well, although the company has these claims to the tune of about £5 million against these guys, we believe these guys are going to work for the company. So because they're going to work for the company, there's no point in suing them for the money. So they can keep their nice houses in Chelsea, whatever, right? That's the bottom line. And then by September 12th, the company goes into liquidation. A liquidator comes, and the liquidator says, well, that's a breach of duty. You have a duty, right, of loyalty. That's a breach of duty. And what protected the directors? The business judgment rule. So that doctrine, which we traced from 1812, we see it being manifested here. And that's why I refer to it as a constraint, right, on the imposition of these duties, right? And I recall last week somebody said, well, why couldn't they use the duty of care, right? Because, you see, when you look at the statement of directors' duties in section 172, it talks about subjective bona fides, right? That's the problem. It's what the directors think. So that's where the protection comes from. But if we move to the section dealing with the duty of care, then you don't have such, you don't have any kind of statement of subjective bona fides, right? And I think that was the question that was asked. I think it was you, Anne, who asked that question last time, right? So if you look at the section, just look at the language of the section dealing with the duty of good faith, which is section 172, and then compare it to the provision dealing with the duty to exercise care and skill, which we're going to talk about, and you'll see that there what we have is an objective test. There is a subjective element, right? There is a subjective element, but the subjective element only raises the standard, right? So it doesn't sort of take the standard low, right? So and I'll come back to that in a minute. So here, I say that there has been substantial convergence in respect of those duties. So when I talk about convergence, I mean global convergence, right? I mean, if you look at the company law systems of your various jurisdictions, right, you're going to see that there's convergence on this. Every legal system has a duty of care and a duty of good faith, right? And I said, and on the constraints to controlling directorial discretion, right? There's also convergence there. And how the different legal systems formulated might be different, right? So maybe in America, they'll talk about the business judgment rule. In English law, we don't use the term business judgment rule very often. Sometimes we do, but not that way. We simply talk about subjective bona fides, right? And then it achieves the same thing. And if you look at the Citigroup case, an American case, and you know, so this is a case where the directors expose the bank to substantial losses. We're talking about horrendous losses. And the directors were not liable, right? So it's kind of similar to Regent Crest, right? Similar to Regent Crest. I mean, people always wondered, after the last financial crisis, how come directors of banks, how many directors of banks do you know who lost their homes? They were all protected. And you see people on the left talking about this as if there's some kind of grand conspiracy to, you know, I don't think there's any kind of grand conspiracy. You know, there's some things that are easier to go to jail for, depending on the jurisdiction. So if you look at what happened to Enron, right? So even though Kenny Lay was always playing golf with President Bush, that didn't protect him. He went to jail, right? Because there were securities fraud violations, right? But when it comes to what the directors do when they manage a company, it's going to be difficult to even pin civil liability on them. Do you get the point I'm making? You know, before you get to criminal liability to start locking people up in jail, I mean, presumably you want to be able to establish some kind of civil liability. These guys are protected, right? They're protected, and that's why we don't have that issue. So that's why I say those two important cases on the constraints in practice. And then I say that ultimately we tend to have a debate on values, right? So notice what I mean. When I talk about a debate on values, suddenly people on the left have a very active debate on this, which is, you know, what goal should a company serve? There's a movie called The Company. I don't know if anybody has watched it. You know, have you watched it? Some documentary on Netflix done a few years ago. You'll see a picture of, you know, those old Victorian pictures of the devil with a fork and a tail. You know, they usually paint them green. I don't know why. You know, so here I think they just changed the color to red. So, you know, the company is bad and the company is a devil and that kind of stuff. And whereas here I come on the first day of the class and I'm even comparing the company to God. And, you know, kind of, you know, that tells you something. Not God in terms of its ability to create as we think, but in terms of our ability to imagine, right? Okay, so that's my sort of anti-blasphemy get out clause. So anyway, you might want to see this. So that's where the conflict arises, and I suppose here the question is, you know, how do we deal with the issue of values? Should companies exist for the benefit of, say, stakeholders, and should we sort of bring that idea into the duties of directors and indeed how we configure the board? So in some cases where you have a sort of two-tier board system, co-determination, you see a stronger voice to employees. In another, so that could be one way you could go about it, to say, okay, let's have a system of co-determination, give employees a stronger voice on the board, right? Another system would say no, and that's what we do, to say we're going to have a unitary board system, right? But within this unitary board system, we will protect the employees' interest, right? We will protect the employees' interest. And in addition to doing this, we will have a liability rule that protects directors. By this I mean, if the directors take account of employees' interest, then they will not be punished, right? They will not be punished. Indeed, one may say that we've gone full circle to actually demand that they do take account of employees' interests, right? So those are debates about values, right? How you how you configure it is a matter for the relevant jurisdiction. In the UK, we simply do this through Section 172. Maybe at this point, I'd like to stop and hear other systems that have done it differently. So I'm referring to the question of values. To what extent do you find the UK system very different from other systems that you're familiar with? Let's get, before we sort of take Europe, let's get, say, Korea, China. I think the last time I checked, there was only one person from Korea, right, in the class. Are there many from Korea? I think it was just one.
No, from Kazakhstan.
Oh, sorry. Oh, God. Where did Korea? I thought I saw. Yes, you. Yes. Yeah. Okay. KK, I suppose. Yeah. Okay. So Korea, Kazakhstan. Maybe you start, and then I'd like to hear from you.
So we have those kinds of rules and regulations also, and some similar theorems or legal theories that also apply in South Korean company law, but quite different in some texts. Like, for example, we have only in Korea and Japan we have auditor, internal auditor, who always work within the company, and it's a little different from the mainland or UK system.
Auditor. What does the auditor do?
Auditors always perform sort of auditing for financial statements and directors' work. So it's the work performed by auditory board in the United States or the supervisory board in Germany.
Yeah. Okay. So what I'm saying, let me maybe to make it clearer. I'm saying that, I mean, what we've been doing so far, we've been talking about subjective good faith, right? We've talked about this. But here we're saying to promote the success of the company for the benefit of the members as a whole, and in doing so, having regard to these interests, right?
Yes.
Okay. That's how we do it, right? So now here we achieve this through a unitary board. We do not believe that we need workers on the board to achieve this, right? And by doing this, by putting these statements there, we also protect the board that considers this interest. You know, the common law previously said if you did consider this interest, you would be liable. There used to be an old case called Houghton and Railway, where the judge said that there shall be no cakes and ale except such as are for the benefit of the company. So if you decide to buy cake and ale for your employees, then you'll be liable, unless, of course, you can show it's for the benefit of the company. So in other words, there was a liability rule. By having this statement, we release directors from any kind of liability, and if anything, tell directors you need to pursue this. Now, of course, the directors will not be sued by the workers, right? Because workers have no standing, right? But that's neither here nor there for present purposes. So I'm just talking about the issue of values, whether different legal systems pursue this. Do you see, right? And then again, the issue of the duty of reasonable care, skill, and diligence is pretty straightforward, right? Because it's objective, right? So there's no subjectivity here as regards the general statement. It's a duty to exercise reasonable care. So there's no subjectivity. It's objective. And however, to the extent that we look at your subjective traits, if you look at the prong in subsection B, where it says the general knowledge, skill, and experience that that director has, all it just does is raise the standard. It doesn't take it lower than the objective standard. So, as I always say, if you come from the London Business School and you've done, corporate finance, then we expect a bit more from you, right? I think that's the point I was essentially making. Now, so the question then is, if systems of corporate law have to go beyond these two duties, the duty of care and the duty of loyalty, to protect investors from the risk of disloyalty, then how do they do it? There's no point just stopping at the duty of loyalty. You need to flesh it out, because if you just have a statement of the duty of loyalty, then you're going to get related party transactions, right? The fact that you have a duty to act in good faith to promote the success of the company does not rule out related party transactions. So we need to have another set of rules. And that's why I say this is achieved by fleshing out the duty. So what I then say from now onwards is that everything you see after 172, it is simply fleshing out, from the duty of care and skill, it is simply fleshing out the duty. To be specific, when we begin to look at section 175 down to 188, we're basically talking about the fleshing out of this core duty, right? Okay, in particular instances, right? So, and I did say that not all legal systems regulate these things well or regulate them the same way. So I think the point I'm making here is that how you flesh out this duty is a matter for your legal system. Remember, I started by saying every legal system will have a duty of loyalty, right? So I'm sure even, I'm sure in every jurisdiction there's a duty of loyalty. But the question is, how does the duty of loyalty bite, right? That really would be the question. How does the duty of loyalty bite? That's why I gave you those two papers. Now, so before looking at the papers, I just want us to be grounded here. So we started with the duty of loyalty, which is section 172. I say it is subjective and therefore limited, right? And then I say the Companies Act fleshes this out further. So, and how does it flesh it out further? It starts from the principle that directors must not put themselves in a position of conflict. So this deals with a situation of conflict. Hence we say situational conflicts are prohibited, right? Now, this is important because what the law seeks to do is attack the position of conflict. So the director himself has not necessarily done anything bad. He just happens to be in a situation where there is a conflict, right? And the law has to deal with this. Then it goes on to basically deal with transactional conflicts. So you need to keep these two ideas clear in your minds. Transactional conflicts are not the same thing as situational conflicts, right? So this is how we deal with it. We basically say, A, you should avoid a situation of conflict, right? So you avoid a situation of conflict, or if you find yourself in a situation of conflict, right, because it's now been foisted on you, right? So for instance, a company could acquire a company in which you have an interest, right? So it's been foisted on you, then the law tries to deal with this. Likewise is where you enter into a transaction with the company, right? There we're talking about a transactional conflict. So when I have to advise on a transaction involving directors, I always ask myself, am I dealing with a situational conflict? Or am I dealing with a transactional conflict? that's how I put things in my head. You know, is this a situational conflict situation or a transactional conflict? So for present purposes, if you're doing an exam, that's what you need to be clear about. Is this situational or transactional? Because different rules apply. Right? And the idea underlying this principle of conflict is that the company should not be disadvantaged and the directors should not make a profit, right, from the position or transaction, right? So that's the underlying principle. So let us now look at three situations. So here we're going to look at section 177 and section 188. Right, so section 177 and 188, sorry, and 182, sorry. And you'll have noticed that I have left out where most people start from, which is section 175. Remember, we stopped our discussion at section 174. Section 174 deals with the duty of care and skill, right? And after section 174, we then have section 175, which deals with situational conflicts, right? And then after 175, which deals with situational conflicts, we then have section 176, which basically stops you from taking bribes from third parties. And then we get to section 177, which basically says you've got to declare an interest in a proposed transaction. Now, what I've done is cut all that out first, and I want to deal with 177, right? Which is that you are entering into a transactional conflict situation. The reason I say 177 is that sort of comes to our mind when we deal with related party transactions, right? A related party transaction. I'm buying property from a company. All right? That's the more egregious one, isn't it? So let's deal with that, and then later on we'll do 175. Right? Okay. So let's deal with this egregious situation. I am buying property from my company. How should this be regulated? I mean, that's a choice that every legal system has to confront. Do we prohibit this, or do we allow it? What do you think? Should we prohibit it? Should a director be able to contract with a company? Yes or no?
Yes.
Yes.
But the interest must be declared.
Okay. Must be declared to who?
To directors itself.
To directors. Isn't there any danger in that? If you're declaring to the directors, then do you think that's fine? Because if everybody then agrees to, sort of nod it over, through, do you think there's a risk? I mean, would you be happy as a shareholder if the directors simply declare it to
To some
themselves?
extent, if the transaction is more than some payments, maybe there should be some approval from.
They should
seek some approval from the members.
From the members, yeah. I saw you.
Yeah, it would the same thing. Like,
The same, yeah.
I think you could buy this house from the company, but if this decision was be controlled by the board before,
Yeah.
contract this.
Yeah. So essentially, when it comes to, remember, we're dealing with transactional conflicts now. We're saying that the law does not prohibit you, right? Because if the law prohibited a director from entering into a contract, then the director himself won't even get a salary, right? Because he collects a salary through a contract. So the law basically does not go down the route of prohibition, but instead it says you can enter into a contract, and as you said, there should be disclosure to the board. And as you said, if it reaches a particular limit, then there should be disclosure to the shareholders, right? So here I refer to 3 levels of rules, right? So here we have a default rule requiring advanced disclosure to the board, hence section 177, right? Now, if you look at 188, it deals with a situation where there is an existing transaction, right? So it deals with a situation where there is an existing transaction. So imagine the director already had an interest, right? And then the company now, so I already have an interest in a particular company or a particular asset, and then the company then subsequently enters into that transaction, right? Then in that case, you have an existing one. So there you have to disclose under section 182, right? So I want us to focus on 177, right? Because 182 simply deals with an existing one. So what 177 does is to say you disclose to the board in respect of a proposed transaction. If you don't have your Companies Act, I better just pull it out here. So if you notice, here we have 175, which we're not going to deal with now. We're going to come back to that. So here we have 177. So notice the language. If a director of a company is in any way, even indirectly, interested in a proposed transaction or arrangement, it's very wide. So the idea of arrangement is even to extend it beyond transaction. And notice that the notion of indirect, then he must declare not just the nature of his interest, but the extent of it to the other directors, right? And basically the law says that you make this declaration before the company enters into the transaction. Now, if the company already knows about it, then there's no point, right? So if you look further down, I think subsection 5, it says this section does not require a declaration of an interest of which the director is not aware, or where, this section does not require a declaration of an interest of which the director is not aware, or where the director is not aware of the transaction or arrangement. And then, so that would be a situation, very rare, but a situation where, for instance, the director is not aware of an interest, right? Maybe has an interest, maybe in a pension fund, which is has certain investments, and then the company is entering into it. What I had in mind, actually, situations under subsection B, where the other members of the board are aware of it. So take the position of your salary, for instance. You enter into a contract in regards to your income. The other directors surely will be aware of it. So that's why it says the director need not declare an interest if other directors are aware of it, right? And then likely, and the other bit to mention is that you do not need to declare if it's not likely to give rise to a conflict of interest. So that's an important one, because when dealing with a transactional conflict, I say to myself, I suppose, one, I have to identify it as a transactional conflict. B, is it a proposed one, right? Then if it is, then 177 applies. Then the next question I ask is this a theoretical, illusory conflict? Is it a real conflict or not? Because if it's so unreal, then I would basically say that this cannot reasonably be regarded as giving rise to a conflict of interest. So that's going to be the way you approach it, right? Now, notice what I'm doing. I'm dealing with the structure of the law before getting to the remedial point, because the fact that you work this out does not resolve the question of remedies. And I just want to separate the issue of remedies for the minute. All right? Now, if we then go back to the other provision, I'm not going to deal with 182, because remember, 182 is simply the counterpart to 177. It is simply disclosure in regard to an existing transaction, right? So at least we're clear now about transactional conflicts. You need disclosure to the board. Now, you mentioned something. You said if the transaction is at a higher level, then we cannot rely on the board. We need to go to the shareholders, right? So I always, again, people tend to miss this. They always miss this bit about a higher level because they say, well, Section 177 says you don't need to go to the shareholders. Well, only if it is not a substantial property transaction. Once it's a substantial property transaction, then you've got to go to the shareholders, right? So this is what I call as the second level of rules. I said this will cover substantial property transactions, loans, and similar transactions and remuneration issues. Now, and I said we refer to these types of transactions as tunneling. The reason why we use tunneling is because these are high-risk transactions, right? So you're buying property and such type. And again, you'll notice that after when the Sarbanes-Oxley Act was passed, that bit was also copied from the UK, which now appears as Section 402 of the Sarbanes-Oxley Act, which basically says, you need to subject this to a prohibition in the US. Of course, in the UK, all we say is you subject it to the control of shareholders. And so that's why here I refer to the approval machinery. Now, I should say one thing about the law. Again, maybe I'll reserve this to the remedial stage, but it's worth knowing, perhaps at this stage, that if there is a transaction in breach of this rule, so you do not get shareholder approval, try and imagine you enter into a property transaction and the company haven't sold property to the director, the property value increases. The company will be entitled to ask the director to disgorge all the profits it made, right? Correspondingly, if the company makes a loss, right, the director would have to compensate the company. So it's a very powerful provision. The clearest case where we see this being discussed is the Dokwari case, which I mentioned, Dokwari and Offer Venture, 1999. It just shows you how strong this rule is. And then there is another level which more or less duplicates the second level, but it's wider, I suppose, and that's a rule which applies to companies with a premium listed, which is to enter into a related party transaction. Now, so bear in mind that we have this rule because we're not sure that a company coming from another jurisdiction, which has a premium listing in the UK, comes from a company law with strong rules, right, on loyalty. Now, we are all agreed that most legal systems, if not all, will have one type of loyalty rule, which will be the core principle of good faith, right? Every legal system will have that. How you flesh it out is a matter of detail, right? So I know that some systems do not flesh it out very well. And if you read the Laporta piece, right, and you look at the case studies they do, you see this very clearly. I mean, and that's why the two articles I've given you are about case studies from different jurisdictions, right? You see that not all jurisdictions are the same. So the idea behind the listing rule number 11, is to have a higher rule which applies to premium listed companies, which more or less replicates English company law as regards related party transactions, right? So that way, when you choose to list here, remember we talked about contractual corporate governance, when you choose to list here, you're sending a signal to the market that you, regardless of your primary company law, you are prepared to abide by a higher standard, right? So that's what I refer to here. So essentially, and when you look at the structure of rules, you now see the picture being very clear. So the starting point, just to recap, is the core duty of loyalty. But the core duty of loyalty is usually not enough because of subjective good faith, right? Those constraints we talked about earlier, which we saw manifest in Regent Crest. So we need rules to flesh out this core principle, because when we have rules, prophylactic rules, fleshing these things out, then subjective good faith does not come in. These rules are clear. You must not do this, or you must do this in this way, right? So the question then is, how do we flesh it out? We flesh it out in section 177 by saying, as regards transactional conflicts, you entering into a contract with your company, right? Our role, our idea basically is that you should not be contracting with your company, right? As one judge said, the shepherd must not become the wolf, right? So do not contract with your company because we feel that you will take advantage of your company. But because we know that in life things have to happen, we allow you contract with your company. However, declare it to the board, first level. If it is serious enough, right, then it may engage section 190, i.e. it's a substantial property transaction, in which case you declare it to your shareholders and your shareholders should approve it, right? And if your company has a premium listing, right, so even if the company is incorporated elsewhere or incorporated in the UK, if it's incorporated in the UK, then there's slight differences between listed rule 11 and your substantial property transaction rules. The bottom line is that the listed rule 11 is stronger. And certainly if you're incorporated elsewhere, then listed rule 11 basically says you need to get the consent of your shareholders. This way, English law deals comprehensively with related party transactions, right? Or any transaction involving a transactional conflict, right? So what I've done so far is talk about transactional conflicts, not situational conflicts. I would like to go into situational conflicts, but I thought you had a question.
Yeah, actually I have two questions.
Okay.
So the first one is, if the director, instead of securing a valuable transaction with the company, decide to resign from his roles, company's roles, and pursue the transaction on behalf of a company which he owns and gaining the profits. So can you prosecute him or not?
So the idea basically is that does resignation sanctify it? The answer is no. Resignation will not. So if you look at Section 170 of the Companies Act, you'll see that these principles, and let me very quickly take you there. So here, I think that's the answer to your question. So a person who ceases to be a director continues to be subject to the Section 175 duty, which I'm going to come to, and the duty in Section 176. And to that extent, those duties apply to a former director, blah, blah, blah. And so again, it's the idea with even if we didn't have this section, I will still say resignation will not save you. All right? The reason why we had this section was just to make it very clear in situational conflicts where it's less obvious. You see, with transactional conflicts, it's pretty obvious that. So if let me analyze it this way. If there's a transactional conflict, it's pretty clear what the issue is. There is clearly a conflict of interest, right? Now, if you resign and then you take advantage of it, it becomes a situational conflict, right? Because you've now profited from your knowledge. So there is no transactional conflict anymore, right? Because you're not dealing with a company, right? Or you've left the board, isn't it? That's your example. But you've left the board with something. With what? Knowledge. Exactly. You've left the board with knowledge, which you now want to take to your advantage. Now, that is a situational conflict.
Okay.
And because it's a situational conflict, to remove all doubt that this is prohibited, you have this section, section 172, which says a person who ceases to be a director continues to be subject to the section 175 duty.
Okay.
Do you see? Right? So that's the structure. Because I thought to explain it, because some people would say, well, this applies to a situational conflict, not a transactional conflict. Therefore, but once you understand that once you've left the company, there is no longer a transactional conflict, but there is a situational conflict if you take advantage of that information. Now, two questions you said.
Yeah, it's a small one. I mean, you talked about the approval machinery. So let's say you have a small company, so not dispersed ownership. So in that case, I mean, the members correspond to the directors are the same persons. I mean, the same member, the same people. So what should you do? I mean, in that case, who should grant the approval?
Yeah. So we'll come to this when we talk about remedies. But basically, the director who
One member.
who has that interest will be disenfranchised. He will not be able to vote.
And can you allow like the 1% shareholders to decide the destiny, the strategies of the company?
No, so remember, so are we talking about the board now or
Yeah,
because there are
the
two stages now, but the
Let's say
shareholder.
The directors are the members as well, because the company is a family company.
Yeah. So but then you see, because once we're looking at the board, regardless of how the company is structured, even if it's a family company, we're just looking at the board. Remember, the shareholders don't get to vote. Now, the distinction between shareholders and the board may be illusory in a family company, right? But the rules still remain. So we'll ask the question, is the family now acting as the board?
Who should grant the approval?
Yeah, who should grant the approval will depend on the nature of the conflict. So if we're dealing with, remember now, we're talking about a transactional conflict. If we're simply talking about a basic transactional conflict, then you report to the board, right? The board obviously has the right to decide whether or not to enter into a transaction, right? If you've allocated governance powers to the board. So you simply report to the board. If, on the other hand, it's a substantial property transaction, right, then you report to the shareholders. So in other words, the board will have to approve it, but it still has to go to the shareholders. Now, in your case, it may very well be that the board are the shareholders, right, because it's a family company. Then we simply disenfranchise those who stand to benefit, who have an interest. They don't get to vote at the board. At the board, that's the key thing, right?
Let's say like the 99%,
I know where you're going. The point is this. Once you are conflicted, then your vote is not a vote. All right? 1% is 1% that is clean, is better than 99 that is dirty. All right? Does that answer? Okay. So now, what I want to do is go to 175. So if we look, remember now, we're talking about this principle that underpins the duty of loyalty. And we see being fleshed out in different areas. So we saw the principle being fleshed out in 177. Now we're seeing the same principle at work being encapsulated in 175. So just to remind you again, I just want you to understand what I mean by the principle. So inherent in this principle is the underlying case law on conflicts and profits by fiduciaries. So the starting point is the principle that directors must not place themselves in a position in which this conflict between duties to the company and the personal interests, arise. And inherent is not just conflicts but profits, right? So these are the things we're looking at: conflicts and profits. And so the way to then deal with it is to divide them, right, the problem areas, into two: transactional conflicts, which we've dealt with, and then now we're going to situational conflicts. And so when we now look at how the principle is encapsulated here, right, here we see the law prohibiting, right? So here there is a prohibition on the exploitation, or prohibiting the exploitation of a corporate opportunity, information, or property. The director is abusing his position if he seeks to do this. In the example you gave me earlier, where the director got some information, then tries to resign, he's exploiting that, and therefore he's abusing his position. Now, the clearest manifestation of this will be if you take a bribe, and that's why Section 176 deals with this. But we see this, right, in Section 175. So a director must avoid situations in which he can have a direct or indirect interest which conflicts with the company's interest. So, and notice, I just want to flag these points before looking at the section. It applies in particular. So that's a drafting technique to tell us that it's wider than this, right? So when you're looking at the section, just bear in mind that the section is actually wider than it claims. It's simply saying it applies in particular, therefore it must be wider. So it's wider than the mere exploitation of property, information, or opportunity, and regardless of whether or not the company could take advantage of it. So your duty, first and foremost, is to avoid this situation of conflict, right? And again, just continuing, I say it is a strict rule. So notice the language says possibly may conflict. So it's a very strict rule. It is immaterial whether the company could take advantage of it. The director's good faith is completely irrelevant. So subjective good faith does not come in. As you said, is resignation a shield? No, resignation is no shield. And now this is one that gave me some, I was finding a way to articulate it, and I hope I succeeded. I say the criteria for identifying the corporate opportunity is loose. And then I say the company has a call option on all business opportunities any of its directors stumble upon. And it is a duty on the directors, right, to alert the company to this call option. The reason I thought about this was that take the case of a guy who, so imagine a company is in the property business. And for some reason the company says, you know what, let's stop. You know, our cash flow situation is such that we can't sort of continue for the next 2 years to buy properties. before then, the company was always buying properties. And maybe at some point before they took this decision, there was a particular property, maybe next to their office, which they had said, wow, can you imagine this property ever comes to the market? That would be great for our business, right? Just in passing. Then 2 years down the line, they've taken a decision, you know, no, things are tight, we're not going to do any property purchases. And then you're a director, and one day you go to a party, and you meet somebody who owns that property next to your company and says, you know, we're thinking of selling this property. So you remember, so first of all, you see dollar signs or pound signs or euro signs, as the case may be. You know, there's going to be a lot of money. And the natural human urge to acquire and appropriate and exclude other people kicks in very quickly. And you therefore think that, oh, wait a minute, the company decided not to make any acquisitions, right? So you're remembering that because you know what your duty is, so you want that to displace your duty. And then to be sure, you go to meet your lawyer and say to your lawyer, please advise me what to do. And the lawyer says, well, the company has decided not to do it, right? At the board, it was minuted, there was a board resolution to that effect, not to go into any property transaction, right? And you found this at a party, not in the course of your office, therefore you can keep it. My question to you would be, can you? Can you take it? What do you think? And maybe, so this would be the time perhaps to look at the law. What do you think? Yes.
Well, I believe this is a case law that
Yeah.
has been decided, and
Yeah.
it was found that the director was in breach of the duty to avoid conflict of interest.
Fair enough. And
He should be respective of the minutes, since he
no, the minutes actually say we are not going to make any property transactions.
irrespective of that, since
Oh, sorry, I thought you said to respect.
irrespective of that, since he got the opportunity due to his position, he should take it to the board.
Exactly. You should take.
decide.
So therefore, you will agree, I hope, and this is why I phrased it this way, that you will agree, I hope, with this phraseology where I say, it was because of that case, right, that I worded this way, where I say that the criteria for identifying a corporate opportunity is loose, right? And so if you say, how? What is it? What's the criteria? How do you know when something is a corporate opportunity? Well, it seems to me that it must be that the company has a call option on all business opportunities any of its directors stumbles upon, with a duty on the director to alert the company to this call option. Do you think I've put it too widely? Well, it may be a bit too wide, right? I mean, think about it this way. I mean, if a company, nowadays companies have broad objects, right? A company can do anything. I mean, if you set up a company with a narrow object, right, and said, our business is to run schools, right? Then if somebody tells me that Kazakhstan is doing an oil licensing round and there's an opportunity for me to apply for an oil prospecting license, I don't think I need to tell my company, do I? right? Because they're completely outside. But if, on the other hand, the objects of the company are, your standard ones, and the company is just a general commercial company, should I have to inform my company about the opportunity in Kazakhstan?
Yes, because your interest will clash with the interest of the company. They can.
How does my interest clash? So because I happen to be a member of this company, there's always a clash. The country is Kazakhstan.
They can dig the oil well
But
themselves.
Yeah.
Extract oil and get profit.
Yeah, I know they want to get profit, but is there a clash? I'll come to you. This is interesting. What do you think?
Well, I'm not sure, but the company does not pursue its business in anything related with that. I don't see how there could be a clash.
Yes. So he says if the company is not in that area of business, right? So the company maybe just runs shops, right, in London. They like money, right? But that's all they do. And then a director just happens to talk to someone in Kazakhstan. The businesses do not seem related. But you're saying that somehow the company has a call option on everything.
In future, maybe they decide to switch.
They may decide, yeah. That's real hardcore, isn't it? Yeah.
I completely agree with what he's just said. And looking at 175.4, if the situation can't be reasonably regarded as likely to give rise to conflict, so if they're just selling clothes on the high street, how possibly is there a conflict of interest if you were to have a conversation about oil in Kazakhstan? I can't see if anyone would reasonably think that this would give rise to a conflict of interest.
What do you say to that? I mean, your answer maybe answers, or at least you may be an attempt to answer it, where you said, well, that's for now, but who says that they may not want to do this in the future? Who says they may not want to apply? I mean, what if, and the reason I came up with the oil licensing thing is it was just something I was working on this morning and just looking at an oil licensing bid, and so in order to apply, you need about $10,000, right, to get the form, and then maybe another $50,000 for something, right? And then all you then need is just people behind you to say, okay, the bank would be willing to, all right? So the money is not that great. So why should this company, this dynamic company, who are always looking for every business opportunity, you remember that program, Only Fools and Horses, Trotter? Do you remember it? You don't. The comedy here with Del Boy. Nobody knows this. My God. So Del Boy is this character who was always on the deal, somewhere in Peckham. But, every business opportunity, he was up for it. And I think, so that's your point. You're saying they may, but she's saying, well, there is nothing that you have done that suggests this.
And the legal rule, I think, it has not any time constraints. It has not any,
So a future conflict? That's what you're saying. No, well, but maybe what you mean is not time, but you mean, it doesn't. Well, okay.
As long as he is director, and if he is director in the future within this company, and he already made this deal to dig a oil well, I think he might be in conflict in the future if the company decides to switch their business and to extract oil as well.
Well, then.
If he stays within the board.
Okay, yeah. Well, then. Sorry.
Sorry, but isn't this a situation which cannot reasonably be regarded as likely to give rise to a conflict of interest?
Well, that's her point. He takes a different point. My answer, let me just sort of draw a line here. My answer would be that the idea of whether or not you have breached the fiduciary duty is fact sensitive. It's fact sensitive. We need to look at the facts. So we can't really set out any clear rule in in isolation, beyond what we already have. Now, so if I look at the facts, and I look at the testimony, and assuming the lawyer was cross-examining the guy in court and had said, did you guys ever discuss anything in this at this level? You know, did the board ever discuss this? And the guy says, oh yeah, well, at some point we thought, you know, if these opportunities come, and you know how businessmen, they're always looking for, you know, just as you guys are always reading your law books, they're always thinking about opportunities, bitcoins today, that tomorrow, that, you know. So the likelihood that there could be a discussion is high. It's not zero. It's there, right? If it's a dynamic young company, even if they're doing stuff there. I once knew of a business that was operating here, running security services, and then later got a contract to do to provide houses for immigrants who had come in, and then later began to operate a trawler abroad. Right? You can see how things grow. It all depends on the dynamism of people. So my point is that if there is evidence led that this company could possibly have this interest, then I would say there's a conflict. Right? But without such evidence, then I agree with you that there is no chance of us saying that there is a conflict. So the bottom line is look at the material before you. Yeah.
Yeah, but why then would it happen to be a conflict in the case of the house where the company has already stated that she was not interested in buying any more property?
Yeah.
The guy went and buy it. So
Yeah. I get your point. Yeah. So because this is a game changer. That's why it's a game changer. Yes, they took that decision, right, because they had some cash flow problems. But the fact that you took that decision does not mean that if you have the opportunity of a lifetime, you will not take it. Right? So it's a game changer. So that's why I say the company has a call option.
So it's more like they couldn't afford to buy the property at the time, not it.
Yeah. But this would change everything. So you see, the essence of this exercise is to get you to look at the facts. That's really the key. And if you notice, I could have easily given the answer you gave to say go to subsection 4, but that would not be the correct way. The correct way is really to appreciate, and you see the judge is saying this in a range of cases, that whether or not you say somebody has breached a fiduciary duty, ultimately it's a question of the facts, right? And so in looking at the facts, you're probably going to get this in the witness statement of the relevant person. If they're foolish, they would volunteer that information. But if they're smart enough, they will not. But maybe under intense cross-examination, it will come out. And if it comes out, then you already have it. That's the point I'm making. Okay. So when I say here that, in effect, the company has a call option on all business opportunities any of its directors stumbles upon to alert the company to this call option, there has to be, it surely has to be read in light of that subsection, right, that you mentioned, right? So in other words, if it's so unreasonable, then there's no duty to alert, right? Okay. And then the other point to bear in mind is that, there is a conflict of interest in a transactional situation, in a transactional conflict. So if I sell my house to my company, there is a conflict of interest. You agree? Huh? There is, it's obvious. But that's not covered by Section 175. People always make this mistake. That's why I thought this year what I'll do is try not to take you to 175 first. Right? I want you to diminish the importance of 175, even though it's very important. Right? So notice the wording. a director of a company must avoid a situation in which he has a conflict or which may pose a conflict with the company. Clearly, if I buy a house from a company, that's going to be, or sell a house from a company, there's going to be a conflict. Then notice, it says, this applies to the exploitation of any property, information, or opportunity, right? So again, you may say, well, this covers it. But look at subsection 3. The duty does not apply to a conflict of interest arising in relation to a transaction or arrangement with a company. So if I'm buying property from the company, that is a transaction with a company. That is a transactional conflict, which, as we saw earlier, is dealt with by section 177. So 175, subsection 3, is a carve-out of transactional conflicts. It's saying go under 177, right, /182 to deal with this. Now, the moment the transaction has been authorized, or rather, the moment, let me avoid the word transaction. The moment the conflict, the situation of conflict, has been authorized by the board, then you're fine, right? So a situation of conflict, once it's been authorized by the board, then you're fine. And notice, remember you were talking about counting directors before? So you see that they are excluded here. The authorization is effective only if the matter was agreed to without the bad guys voting, right? So that's why I said, regardless of the number, we exclude your votes, right? So now, so let's go back to this. So remember, I say that authorization by the board will cure it. But authorization has to be done with loyalty, right? So if you have a problem question and there is a practice of you scratch my back, I scratch your back, then that authorization itself will be tainted, right? Because the directors who are authorizing, you expect them to authorize in light of their section 172 duty, the duty to act with loyalty to promote the interests of the company. And so what I've done here, and I'm not going to waste time, but I would ask you to look at it, is this. Look at the examples provided by GC100. GC100 is an association of general councils of companies in the UK. So the top 100, the idea is, they've come together, they've created this association, and they've given examples of situational conflicts, right? And so look at them. So if a director of company A is a competitor in some respects of company A, right? So you sit on a company and yet you're competing with a company. If a director of company A is a major shareholder in company A, who would have thought that? So you are a director in a company, right? And you are a major shareholder. It's basically saying there's a situational conflict. Now, it doesn't say you shouldn't be a shareholder, a major shareholder. It just says, let people know. So assuming people didn't know and your shares were held by trust, it's saying you have a duty to let people know. If a director of company A is a potential customer of or supplier to company A, so here, potential, you've not entered into a transaction. If you enter into a transaction, then it will become the subject of section 177, because then you'll be dealing with a transactional conflict. If a director of company A has an advisory relationship with company A or a competitor, right? So you're a lawyer sitting on the board of a company, and you regularly give legal advice to the company, right? Again, there is a situational conflict. Or even if you give legal advice to a competitor company, there is a situational conflict, right? So you can go on, you see, they're not very obvious. Try and imagine somebody, usually in examination questions, we don't sort of make them as complex as some of these would be, but think about that, right? It's the situation of conflict. That's the key thing that we're really focusing on. Now, in regards to the approval machinery, we've talked about that in terms of prior approval. Does anybody have any questions? Remember, I'm not going to talk about Section 176, which deals with the duty not to take bribes and all that, because that's pretty self-evident. Yeah?
And the authorization means the board allow the existence of the situation of conflict with the session director.
Yeah. That's it. Yeah.
Okay. Okay. One, the director, they know the opportunity for the company, but the board decide not to catch it. So can the director do this business or catch this opportunity by themselves?
Okay. So in other words, the fact that an opportunity comes and the board, and then you bring it to the attention of the board and the board says no, does that kind of whitewash things for you? The answer is no. And the reason, the reason is that if it were so easy, then we'll be looking for every reason why the board should not accept, right? Whereas the idea should be that you as the director should look for reasons why the board should do this, right? So it will not whitewash it. And that, by the way, takes me to the question of remedies. Because in all of these situations, if there is a breach of these rules, then what's the position? Remember, if you're going to give advice, you need to know your remedies. Sometimes people just stop at, oh, you've breached this rule, and then they stop there. Your client is not telling you to tell them what rule they breached. As far as your client is concerned, he doesn't even need to know the rule. He wants to know how much money will he get in his pocket, right? So as regards remedies, you need to turn to Section 178. Now, when you turn to Section 178, you'll see that 178 doesn't really tell us much. It just says that, well, you know, in regard to these breaches, we need to go back to the case law, all right? Because they didn't have time to codify the case law. That's really the reason. The Law Commission did not have time to, they had actually appointed somebody to come up with a statement of remedies, and I think it just became too complex. So essentially, what they've done is to say, all these duties we've been talking about, right, from Section 171 to 177, go and read the case law, you will find a remedy, which is good news for us, right? Because you don't want the client to just know the law instantly. The client needs to come to us and ask for the answer, and then you find a way to get the client to part with money. I mean, I hope I'm not too, but that's the way it works, isn't it? So, if we look at 178, right? So the consequence of breach or threatened breach of Section 171 to 177. 171, by the way, talks about the duty to abide by the Constitution, right? So unconstitutional behavior is not allowed. I just thought to mention this. So 171 says, do not enter into anything which breaches your Constitution, right? Well, most times that's not going to be the problem we deal with. So we then move to 172, which we talked about, 173, 174, down to 177. It says the consequences are the same as would apply if the corresponding common law rule or equitable principle applied. So it's going back to the old rules which were preserved. Then it says that the duties in those sections are accordingly enforceable in the same way as any other fiduciary duty owed to a company by its directors. right? They're enforceable in the same way. In other words, you know, the duty will be enforceable by the company, and of course, if the company is in liquidation, the liquidator of the company will be the one to enforce it. So talking about the remedies, I want to just take you to section 180, which basically deals with situations of modification of the duty. So you use the Articles of Association to modify the duty, and it deals with situations of ratification, so what we call ex post ratification. So basically, what it's saying here is that everything is subject to the Articles of Association. That's really what it's saying, that the shareholders can modify these rules, right? The shareholders can modify these rules. So what it means by these rules would be section 175, which deals with situations of conflict, situational conflict, and section 177, which deals with transactional conflicts. And it is basically saying that to the extent that the Articles of Association may prescribe a different rule, then that would be fine. And then so if you look at subsection 4, you see that it deals with what they call antecedent modification. So that it has always been possible under the law to modify these duties, right? And let me just pull out the precise section so that you see this. So notice it deals with section 175, 177. It says it basically says that in a case where, so if we take section 175, where let's say you've made a profit, the transaction is not liable to be set aside by virtue of any common law rule or equitable principle requiring the consent or approval of the members of the company. So the old common law rule, which previously would be to say that the shareholders need to ratify such conduct, right, a breach of your situational conflict rules, essentially it's telling us that that does not apply unless of course the shareholders themselves have said in the articles we want it to apply, right? So let me explain this again. You know, the common law previously had said if you make a profit, right, if you take advantage of your position, right, the only protection is if the shareholders ratify it and forgive you. That's the common law position. So now we have section 175, which says, well, you can take advantage if, right, you declare to the board, if it's authorized. Now, so if it is authorized, then it means that we have conflicted with the old common law rule, right? So that's what it's addressing here. It says, well, that old common law rule is hereby overridden. However, if you really care about the old common law rule as shareholders, you can put it in your articles to say, under no circumstances should our directors do this, right? So that's it. And right, and also if you look at section 4, it says the general duties have effect subject to any rule of law enabling the company to give authority for anything done by the directors that would otherwise be a breach of duty. So in other words, the company could ex ante authorize the conduct, right? So essentially, what the law here is saying is that the shareholders can, in the articles, authorize this, right, ex ante. So, and that's why you need to be aware of this. Again, in exams, it's not going to be tested because usually we will not go to the articles to start changing provisions of the articles. So you'll be left with the default position, right? Which is what we've been talking about. But in practice, assuming you were to advise, you will need to ask the question, have the articles been altered in any shape or form? Because this could affect how things apply. So I would go back to where I was. I won't spend too much time on this because presumably Nigel will deal with those issues. I just want to say, in regards to judicial relief, this is something I want to focus on. In regard to judicial relief, whenever you're advising directors and you discover that directors have breached their duty, always think about the possibility of asking for relief. In other words, under Section 1157, you can ask the court for forgiveness, right? You can ask the court for forgiveness. And how does it work? You basically say that, well, the director acted reasonably on the facts. You know, he wasn't a bad guy. He acted reasonably. You know, which would be strange because if it's a breach of the duty of care, then by definition you're saying the director did not act reasonably. So now, so notice what's going on. On the one hand, you said the director acted unreasonably, hence he's guilty of a breach of the duty of care. Yet, under Section 1157, you're saying that please forgive him because he acted reasonably. So how can an unreasonable person, somebody who is unreasonable for purposes of breach, become reasonable for purposes of liability? It's a bit strange, but the law basically allows for this. So there's a case called Regina of London where the director in question filled out some insurance policy which asked certain questions which he answered incorrectly. And the consequence of answering those questions incorrectly was that the insurance company repudiated liability when the risk eventuated. I think there was a fire or something like that. So the insurance company said, well, you didn't answer the question correctly. Now he said to the insurance company, well, I was in a hurry. I didn't read it. And I just signed. So now the liquidator brings an action against the director, right? Saying that this loss, which the insurance company did not cover, we want the money back from you because you acted without care. So it was clear that he acted without care in not reading the document, right? Because it wasn't a massive document, right? It wasn't like some 80 pages of turgid legal prose. It was a simple document that he could have read in 5 minutes. So he then goes to court under 1157 and says, well, yes, I am liable, but I want to be excused. And under 1157, the court granted that excuse, right? So it's possible to be unreasonable in that sense for liability purposes, for breach purposes, and then to be excused. I just thought it's always good when people are arguing a case in an exam to say, finally you get to a point where you say, well, but even if we can't sort of sustain this case and get the director off the hook, clearly under Section 1157, here are the grounds, right? So the kind of grounds you'll be looking at will be honesty. This guy was honest and all that. Let me give you an example of how this could apply. Take the clawback claim in Regent Crest. Remember, Regent Crest was decided under Section 172, and subjective good faith came in. And I said that, for me, that was an abuse of subjective good faith. And I thought, I wondered why, and I think somebody asked the question, why wasn't the case argued under the grounds of breach of the duty of care? Because had they done that, then there would be no subjective good faith. But had they done that, the answer to that case would have been 1157, to say the Ridgencrest brothers, right, these guys who meant so well for the company, put in so much money, into the company, they acted reasonably and they ought to be excused, right? So that would be the kind of situation that I have in mind. And then finally, just on this other point, Section 232 sort of outlaws provisions in the articles which purport to exempt directors from liability, right? So the background to this was that there used to be, the way the law developed was that you could write provisions into your articles relieving directors from liability. And so the law basically came in to outlaw those clauses in Section 232. However, when it outlawed it, it made it clear that this did not affect, D&O market, the D&O insurance products, right? Because, directors and officers have insurance policies that companies basically get to protect them. So there's a carve-out for that, right? So I mentioned 232 so that you know that it does not affect that market, right? In fact, the old corporate governance code actually said that every company should get D&O insurance for their directors, right? Okay. Then avenues for judicial enforcement, right? This brings everything together, right? Because usually in any question, if the question could be, at the end, it could say, advise the liquidator, then things have really gone pear-shaped. The company has gone into insolvency, and the liquidator is asking you for advice. And then your job as liquidator, right, would be to go through all the facts and look for those rules that the directors have breached, right? Those rules which I call the ex post rules, those rules which set up the duties, right? Not the code. The Code on Corporate Governance will not give rise to cause of action, right? The Code on Corporate Governance will not give rise to cause of action. However, when talking about the duty of care, to substantiate your points, you could say, well, they did not comply with the code, right? And this would be evidence that they have breached their duty of care, right? So you kind of go over the facts and look for the causes of actions, right? Based on the sections we've talked about. And then if I were you, if I were advising the liquidator, I would look for arguments to nullify Section 1157, right? Because I know the other side will come up with Section 1157, so try to nullify it. And then say that, okay, I want my remedy under the gateways that I can proceed. Usually the liquidator will be proceeding under Section 212 of the Insolvency Act for misfeasance. In some cases, under fraudulent trading or wrongful trading. But in a lot of other cases, the company has not gone into insolvent liquidation. It is the company that is asking you for advice to proceed against the director. In other words, there has been maybe a boardroom coup, or the other directors think there's fraud or whatever, and they want to move against that particular director. Again, there's no problem, right? There's no local standard problem because the board has power. But it becomes a bit complex when a shareholder comes to meet you. So if a shareholder comes to meet you to say, advise us, what are our remedies? Guess what? You'd be very good when you, if I were you, you brief him, you divide your work into two phases. You say, I'll give you legal advice, and you pay me my fees for legal advice, right? And then the second bit will be litigation. Never collapse them into one, in this case. Let me finish. So legal advice would be the opinion you give, basically saying, you've breached this duty, that duty, that duty. But guess what? You can't get any legal action, right? Because you're not a company. In order to bring a legal action, you need to bring a derivative action, which is a bit more difficult, or an action for unfair prejudice, right? And then if the client wants to go a stage further and become really bold, then you bring such an action. So this is why I've identified these heads. And it's important you bear this in mind, that these heads are the sources of the law on directors' duties. What we call the law comes from these various heads. So when I read cases on fraudulent and wrongful trading, I get statements from the judges on the duty of care. When I read cases on misfeasance on Section 212 of the Insolvency Act, I get case law on the duty of care, loyalty, everything, right? And then actions by the company through the appropriate constitutional organ means there is no problem in suing. The board has decided to sue the bad guy. Proceedings based on unfair prejudice means that a shareholder who is a minority has been able to say, you know what the board has done or what a particular director has done is unfairly prejudicial to my interest. I want a remedy under Section 994. And derivative claims by minority shareholders, the same thing, but the difference is that they're asserting it in the name of the company, and therefore they want the company to pay the lawyer's fees. And then lastly, telling the government to disqualify the directors. Yeah, you had a question.
Yeah. So let's assume that the company is going into insolvency. So can the liquidator bring a claim against the law firm which had worked arm to arm with the directors?
For what would they claim for the law firm be?
Like for advices, like.
Yeah. So the liquidator can bring a claim. Remember, the liquidator is stepping into the shoes of the company. So if the company could have sued the law firm for bad advice, then the liquidator can sue. Yeah? Because remember, the liquidator is a company.
Okay.
Yeah. Are you planning on suing a liquidator? A very specific question. So are you planning on suing a law firm? That's what I meant. It's, the moral of the story is give good advice. Huh?
If they are both corrupted, the director